Welcome to the Stephen Hasner Show. Today we are talking about how to get the most value out of a workers' compensation case. Okay, today I have Pearce Taylor is joining me. He's a stud workers' comp lawyer at the firm. Pearce spent years representing employers, insurers, and thankfully now he's fighting for injured workers and their families. You have anything else to add about your background?
So I grew up around lawyers. My dad is a private investigator, and some of his closest friends were all attorneys. My older sister is an attorney as well, and it just seemed like the right path for me.
So Pearce, we're talking about how to get the most value out of a case, and we can talk start to finish. And you can talk about non-litigated versus litigated, some certain things. Explain certain things that you do on cases that help get value.
Okay. So from day one, we are assessing overall value and what we can do for the client. And our steps towards whatever resolution, most of the time it ends up being settlement, is driven to try to get everything that the client is entitled to. The employer and the insurer in Georgia workers' comp generally has control over who a claimant will treat with if they follow all the procedures set forth to establish a proper panel of physician, using it, and properly composing it. If they do that, then we would have to choose from a provider on that panel of physicians, generally. If they don't do that, then we can fight to try to get the client in with a physician of their own choosing. That can be a major point, a major issue in order to increase value or to get all that a client would be entitled to.
Yeah, and it's just an unfortunate reality of the system that certain doctors will give opinions on certain patients that just because it's workers' comp may be more conservative than if you went it on your own. So choosing the right doctor on that panel, not only to help you get the treatment you need, someone who's going to actually go to bat for you as your treating doctor, is significant. Once to get the medical treatment you need, but then for settlement purposes, for increasing value can be huge. And then if there's no panel, like you said, obviously pick your own doctor. We can make recommendations, someone who's going to be fair and supportive that can also help. Something came to my mind, to maximize a case, there may be, and there's so many different scenarios, but let's say a doctor is recommending a surgery, they're denying the surgery. How do we maximize that? We've got to talk to the doctor, get questionnaires from the doctor to support that the need for surgery is related. We put the case in litigation to put pressure on the insurance company. And the reality of what we do in workers' comp and personal injury, if you're not putting pressure on the insurance company, if you're not building your case, building the evidence in the case and have it in a position that you're focused on going to trial, you're typically not going to get maximum value on that case.
Right.
If you're just flipping the case around, not doing much, and then go to settle the case, you're not going to get full value from the insurance company.
And getting the full medical records also helps in that, because you don't want to be blindsided and see and not know something that occurred, or having some of the initial records that are saying that multiple body parts are included, but then one or two of those body parts drop off as far as them getting treatment for those. If we get those initial records, we can go back and show, no, they've been complaining about all of these since the very beginning.
Yeah, that's a good point, because sometimes there's multiple body parts. The insurance company wants to authorize or pay for one or two of those. When there's three or four. We're making sure that you're including them all, because again, the more involved, the more treatment involved, the more exposure in the future is going to increase the value of the case.
Absolutely.
So we talked about medicals and making sure the client's with the right doctor and helping the case and helping them get the care they need. And then when it comes to weekly checks, which is a part of the workers' comp system, how are we making sure that the amount they're receiving is accurate? Because obviously, when we talk in a few minutes about how we evaluate a case for settlement, so much is tied into that weekly check amount.
Absolutely. The average weekly wage and then the compensation rate is what drives what a claimant is entitled to per week. and that is a huge portion of what goes into settlement. The way that we can confirm that is we can get their actual wages, but to use their actual wages, we need substantially the whole of 13 weeks preceding the date of accident. If that's
Which is
not,
3 months.
if that's not available, then the next step that the statute requires is to use a similarly situated employee's wage records for that same period of time. And finally, if that doesn't exist, we use the contract rate of hire, so the hourly rate, and then how many hours they would generally work per week.
Yeah, and all that's important from the statute because we're trying to maximize how much the client is receiving while they're treating, and then when we resolve a case for how we evaluate, which we'll explain. I hear stories all the time where people aren't requesting the payroll records to confirm because the adjuster will come up with their own calculation, start paying, and say this is accurate when it's not. I just had a case recently where the adjuster used 5 weeks of benefits because the client only worked 5 weeks, but sent a similarly situated employee that also didn't work substantially the whole of 13 weeks. And then was trying to make there were arguments over what was the correct amount. So we're going to fight to make sure the amount is correct and is maximizing because it's got such a huge effect while they're treating and then when we evaluate the case.
Sure. Another, I guess, pitfall of that is oftentimes adjusters will also just use the contract rate of hire, and that completely ignores any type of bonus in that consideration for the average weekly wage and compensation rate.
Yeah, absolutely. It's important to continue the communication process with the client as they're treating.
Oh yeah.
Because the client's going to call and tell hey, this is what the doctor's recommending. We're obviously getting updated records regularly. You don't want to be a lawyer who's not getting updated records and just relying on what your client tells you. Well, one, you have to talk to the client, and not 100% relying because you want to see what the doctor's recommending and how that matches up, and then making sure they're receiving the therapy they need, the medications they need. Things that are being recommended by the authorized treating physician. Because again, when you're going to resolve the case, the more treatment they're receiving on an ongoing basis that's costing the insurance company more is going to lead to more value for the case.
Right.
Of course, it's based on what the doctor's recommending to them. We're not making up they need something. It's because the doctor's saying they're injured, they need this care, or there's diagnostic studies that are being recommended. An MRI is being recommended. Make sure we're getting that MRI because that can demonstrate more significance of injury or need for surgery and those kind of things that can raise the value of the case.
Right. And speaking to the client, first off, establishes that relationship so that they trust you. And then if you can talk to them about what happened during the doctor's appointment, if they tell you something the doctor was talking about that doesn't make it into the report, then we know that maybe a conference is warranted with that doctor to see what their opinion is on that.
Yeah, and that's why it's important to have really good paralegals because they're doing handling a lot of those communications on a consistent basis. When it comes to we have paras that are putting medical appointments on their calendar. They know when the clients are going to the next appointments, making sure they communicate about, even if the client doesn't call us, that we're calling to say, hey, what happened? How did it go? What did the doctor recommend? Was there any changes to your work status? Because being on top of that issue too can affect checks and rights to checks. What the doctor's opining on work status, so then that can affect the value of the case.
And there's also a sweet spot to settle too. If we think potentially that there's going to be a change in treatment where they may require less or that their work status might change, it might be a good consideration to try to get a settlement going, especially if they're still on income benefits.
Yeah, timing is very important, and if we're not on top of that regular communication and kind of what you kind of are reasonably expecting based on so many years of experience of what doctors are going to do over time. Right. But when you can settle a case in October for maximum value, it's almost like a bell curve.
Absolutely.
There's some curve you can look at to say if you're not on top of your cases and you let that case drop down the backside of that bell curve and now you're going to settle, it's worth less than it was 2 or 3 months ago. Right. And the client is trusting us and relying on us to tell them when is the best time to maximize the case. Right. So,
and we have experience with a lot of these doctors for years. We've been seeing their opinions. We can kind of tell, judging by language that they use in their reports, where things might be heading.
Yeah, that's good. determining the right time to settle, there's a lot involved. Yeah, a lot of factors. But one is definitely where are they with treatment? Because if it looks like it's going towards a surgery, pain complaints aren't improving, things are actually worsening, and there's diagnostic studies, an MRI, CT scan, whatever it is demonstrating that there's a really significant injury, and doctors in comp are generally going to provide conservative care for a while to see how you recover. Clearly, we don't want to be settling that case short, because we want to make sure if they can get the surgery paid for and recover, great. If the client wants the surgery. So in that case, you're just following it and timing. You never want to settle too soon. But then, like you're saying, the cases where maybe there's not surgery involved, they're getting the conservative care, they're receiving checks, you wait too long. So it's following that case and understanding timing of, more likely than not, they're going to not continue physical therapy for 6 months or 9 months.
And we can only look at 3 buckets. We're talking about those. It's medical, income benefits, and then permanent impairment. If we wait too long, we lose out on a lot of those buckets.
Explain how you evaluate those 3 buckets, and kind of how you would take a client through a settlement evaluation.
Sure. So when we look at settlement, we're looking at these 3 areas of medical benefits, both past and future, income benefits, again, both past and future, and then the permanent impairment, the PPD benefits. Looking at medical first, a lot goes into that. We're tracking treatment all along the way, and we do have the experience to see what these injuries are and what we have seen in the past as far as these signs are showing potential surgery, or if there's some sort of partial tear. That could require physical therapy. It could resolve with time, but a lot of times that could require surgery. And so we have this experience to look at these, and sometimes you do have a doctor saying specifically what they're going to need in the future, and that is the easiest case.
Yeah, I mean, the doctor's making recommendations. Obviously, it's easy if the client's on 3 or 4 medications. You can evaluate the cost of those meds over a certain amount of time and decide what's reasonable. The statute only allows, on a non-catastrophic case, for rights to medical care of 400 weeks post-accident. And then weekly checks is typically, the max is 400, but if you're on restrictions, it goes down to 350 weeks, and we'll talk about that bucket. Sure. I think what's important too is we do a lot of times we're doing our own evaluation based on the size of the case. If the case is significant enough, we hire nurses to do medical cost projections. So it's not just us putting numbers down. That costs money. You're adding an expense for the client, but if you're taking these cases and you need to be making sure you're willing to pay for expenses that are going to help build the value of the case. So if I'm going to spend $1,000 on a medical cost projection, and it's going to have an ROI of 20, 25,000, 50,000, whatever it is, obviously that's beneficial for the case and for the client. But I like it because it's not just lawyer coming up with an evaluation. We've got a nurse, and I make sure it's clean. Sometimes it's got these extra things, and I say, no, I want what's really consistent with what is likely to be future medical care. Yeah. I have a case right now with prosthetics involved, and it's excellent to have a nurse evaluate and do a medical cost projection. That's a more expensive one because it's a potentially catastrophic case. But we talked to the prosthetician. The life expectancy of the prosthetics are 3 to 5 years. We use 4 years to be reasonable. And he's got 2 different prosthetics over a 50-year life expectancy, which obviously is helpful to raise the value of the case. I had another case where someone was, had 7 back surgeries, significant case, but he's actually, he never stopped working. Even with all those back surgeries, he continued to receive income. He's an IT worker. He's, vice president level. But a significant portion of the case was medical, so the medical cost projection really helped us because he was taking a significant amount of medication to function.
Absolutely.
And had a lot of other needs that he had. So that's just another awesome way to increase value in the case.
Yeah. And you mentioned a good point when you're talking about the prosthetics, because up to a couple of years ago, medical benefits in a regular workers' compensation claim was limited to 400 weeks. But there's a relatively new provision that prosthetics, joint replacements, medical devices, things like that, have come with them lifetime maintenance. So an easy example would be a hip replacement. Those do have a lifespan. After a while, they have the potential to give out, and there's a potential that they may need another one. The employer and the insurer would be on hook for the lifetime maintenance of that now.
Yeah. So we're talking about ways of filling the bucket.
Yeah.
We know it's something that now is lifetime benefits. We want to make sure we're including that in the demand.
Absolutely.
Yeah.
Absolutely, and that brings pretty significant value.
Yeah. So let's talk about weekly checks.
Yeah. So as we talked about before, weekly checks are going to be driven by the compensation rate. So that is taking those weeks prior to taking similarly situated or the contract rate of hire. We were saying before, ensuring that that's the correct amount is pretty vital because it could be leaving a lot of money on the table. But what we look at is the circumstances of the case. If the case is rather significant, generally we will evaluate it through the statutory cap. And that can be either 400 weeks or 350 weeks, depending on whether the employer and the insurer file a form called a WC 104 while an injured worker is on work restrictions. Other cases, it's possible that they might return to work at some point. The employer and the insurers have the ability to return someone who is on work restrictions to suitable light duty employment. And a lot of those will factor into the ultimate value of that case. Certainly, we are tracking everything and making sure that they're crossing their T's and dotting their I's on that return to work because it's a very specific process. But when we look at it, I like to look at the actual facts of the case. I don't think it does any benefit of throwing some crazy number that the other side's never going to pay.
Yeah, and I think that's a great point. We want to maximize the demand, and you're not making a demand for what the value of the case is ever,
Yeah.
but you're also not sending such an unreasonable number that has no reasonable basis.
Right.
Sometimes they'll just say we're not interested in settling, and that's not in the
Exactly.
best interest of your client. So it needs to be high, but it needs to have a reasonable basis. So certain cases we may not go all the way up to 350 weeks post accident, and we typically do a present value calculation for our demands. It based on the injury, we may do it less time, but it's still something. There's plenty of room, to negotiate because you start somewhere on a demand. There's going to be a negotiation in the process, so you have to leave room for your client.
So the basics of negotiation is we start high, they start low, and then we push each other. We have to come down, they have to go up. If we don't, they don't.
Yeah. And I think your relationships with the defense bar, your reputation, they know we fight. They know we're willing to go to court. You talked about past. Sometimes it's clients have received everything in the past, and we're just evaluating, the case, these buckets of medical and weekly checks for the future. But sometimes we're litigating over past checks.
Right.
And not every case is strong. There's sometimes there's strength, sometimes there's weaknesses. So there's risk going in front of a judge. So the parties come together typically to try to resolve the case, and you're including every benefit from the past, as part of your evaluation. So it's important to make sure you're clear on all those past dates that they're missing checks.
Right. And I should also mention that an injured worker would be entitled to those weekly checks only so long as they're suffering what we refer to as an economic disability. If they're still working and they're still making as much money as they did before, whether for the employer that they were working with when the injury occurred or a subsequent employer, generally at that point they wouldn't be entitled to those checks. So that would be a situation where we may not be reviewing future income benefits.
Yeah, that would affect that bucket the weekly check bucket. So the third bucket is dealing with impairment benefits. They're in the statute. The doctor looks to the 5th edition of the Guide to Evaluation of Impairments and gives an impairment rating. Doesn't mean every case gets one. Sometimes it's 0%, and we have to get another doctor to analyze it if we think it's incorrect.
Absolutely.
But they're given a rating, a percentage. Let's say they had a shoulder surgery, and just for math, maybe it's easier to say 10%, even though surgery likely would be higher, like 15 to 20, percent. They're given a percentage, kind of explain how the statute works when they're given, my example, the upper extremity is 10%. How would that work?
Right. So when they're given a rating, we have that percentage, and then there's a chart in the statute that corresponds with the particular body part injured, and the maximum amount of weeks that they would be entitled to benefits if it was 100% disability. We don't see that. We see 10%. We see things on the lower end, largely because if somebody still has function in that extremity, in that body part, then it would only be partially impaired. So there's a calculation that we do is we take the maximum amount of weeks, we multiply it by the percentage of impairment, and that gives us the amount of weeks that the injured worker would be entitled to benefits at that compensation rate. So the same rate that they would have been getting these income benefit checks. And then that we can multiply by the compensation rate and get a dollar amount on what that percentage of impairment would be.
Yeah. So my example was 10% to the shoulder, which is 225 weeks. So it's 22.5 weeks.
Right.
Times the weekly check amount.
Exactly.
Again, these two of the three buckets dealing with weekly checks and impairment benefits, the amount of your check is very significant. I think it's completely unfair and unjust in the system, honestly, that third benefit based on permanency of an injury is tied to how much you make.
Right.
I remember having the nicest lady, had 2 back surgeries. Her comp rate was less than $100. And I had to tell her, she's crying in my office. I'm having to tell her this one bucket for the permanency of your injury for 2 back surgeries to your spine is you're going to recover $7,000.
Yeah.
And she's crying in my office, and it's I can't control what the statute does.
Exactly.
I think it's unfair because you make $725 a week in weekly checks versus someone who makes $100 a week with the same injuries.
Yep.
She's got to deal with that for life, be in pain, medications, have challenges. I'm sure she's going to aggravate it. And I got to tell hers is $7,000 while this person is, 7 times that or whatever it is. So it's not a fan of that part of the statute, but it is how it reads. And so one thing is really important too is you want to make sure if you're a lawyer, understand those guides to evaluation of impairments. Don't just trust what the doctors are saying. A lot of doctors will send a physical therapist to do an FC or functional capacity evaluation with an impairment, but don't always just trust that that's correct and that's accurate. Understand, you should have familiarity because we see these back injuries all the time.
Absolutely.
How much a single level fusion should be, a 2-level fusion, a 3-level fusion. Prosthetic, someone has a hip replacement or shoulder replacement or something in the knee, you kind of know the ranges because through experience you're seeing these things. So if you see something coming in too low, hey, doc, this isn't correct. You can send them the chart, do a conference call like we talked about, increasing value of medicals to say no. And a lot of times they'll say, you're right. I just gave a number and they won't maybe tell you how they did it, but that hey, this is accurate. But we can do an independent medical exam just on impairment benefits if it's significant enough for the client. Because again, we're talking about boosting the value of the case. There's 3 buckets. There's no pain and suffering. We can't let one of those buckets not be, maximized.
And those FCEs can be very limited too. They do test a lot of different things, but they don't test everything that goes into that injury. We get those FCE results that'll come back with potentially permanent work restrictions and then an impairment. But what they looked at was how much somebody could lift. They didn't look at a number of different factors that would have gone into their ability to actually work and their ability to function later on.
Yeah. So we evaluated these individual buckets, and then we put them together, right? Which comes to, okay, we're coming up with kind of the worst case scenario reasonably for the insurance company on the case.
So we say worst case scenario for the employer and the insurance company. This is the amount that they would have to pay over, a long period of time, years and years, a lot of the time. And a lot of that money is going to go to a doctor and not necessarily the injured worker. So what we do is we're looking at the entirety of what they're going to pay, and we're coming up with our starting number, somewhere close to that, somewhere reasonable, but pretty close. High. Yeah, pretty close to what we're saying is the maximum. That's just our starting point. That's us getting our player on the board. And then if the employer and the insurance company are interested in settlement, they come back with a low number and get their player on the board.
And then there's cases negotiate, and a lot of cases go to mediation. where the parties get together. There's a third party neutral that the insurance company is typically paying for. We're usually involved in who we're selecting for that particular case. What's great about mediation is that everyone is focused on your case or that case at that time versus if it's email or phone. We're obviously working multiple cases every day. So it may take time. You make a move and it may take time for the defense attorney, if there's a defense attorney involved, or the adjuster, if there's no defense attorney to respond because they're working on other cases.
Or they're on vacation.
Yeah. But in the mediation, everyone's focused. When we send a demand out, the insurance company or the defense lawyer or the adjuster is getting settlement authority. A lot of times the adjuster won't have that much in desk authority, and they have to go up. This is why our experience representing insurance companies.
Absolutely.
They have to go up the ladder to their VP, or sometimes if it's big enough, it may be
a board
of people who have to make a decision. So when we go to that mediation, they've evaluated the case from their perspective, have come with a certain amount of authority to settle the case, and our job at that mediation, and this is what's interesting, some people will say our job is to settle the case, and yes, we want to do what's right for our client. If our client's ready to settle, it's the right timing for the case. Certainly. It's true. But if my thought process is to settle the case, that means I'm going there kind of no matter what to try to get this case settled. My job really, and I believe our job, is to get full value for the case.
Sure.
So what arguments are we using? What kind of communication? How are we signaling our moves?
Yeah.
There's so much psychology involved in the process of a mediation to what you're sending to the mediator, because you got to be careful how much you're telling the mediator.
Right.
Because the mediator's job is to settle the case because they feel good about getting the case done. That's their job as a third party neutral. It's a lawyer in workers' comp. They have a lot of experience. They're not a party to the case. They're not representing anyone. But I love kind of going into a mediation with a goal, but kind of knowing what the range is to settle the case. But I'm pushing and signaling that goal because that is still within the high end or reasonable range of what the case is worth.
Absolutely. You're maintaining expectations with a range too. You're not going in with a solid number. You're saying, well, we could get a good result if we can get them to come up between these two numbers. The other thing was we're employing tactics and everything. You were saying how we signal the numbers that we're showing. We're also looking at other numbers that aren't necessarily explicitly said, because we're looking at sometimes brackets where we're proposing you go to this, we go to this, but when in reality we're looking kind of at that midpoint.
Yeah, and it's such a crucial time because it's, again, everyone's focused on the case. This is the one shot to get maximum value, and then I feel like it's our jobs to push, and you hear no, you don't just say, okay, good, we're done. It's I want to hear no multiple times because we're really pushing, going, no, you're not looking at this issue the right way. It could be a litigated issue that's, about checks, and say, no, you're not looking. We feel confident. Look at who the judge is on the case. Here's our legal arguments. You're not going to win this issue.
Try to make sure they actually make that phone call.
Yeah, I mean, you want a case on motion over a shoulder surgery recently, and them trying to minimize what they pay on the case, going, no, we're in the power position. We won the motion. The judge has already said, my client is authorized to have this surgery and ordered it. Like, you're going to have to pay some money if you want to settle this case pre-surgery. Again, assuming the client wants to settle pre-surgery.
Right.
So, it's using, all the things that you learn in your experience to negotiate with again, it's a little bit different because you're working with a mediator that's involved in the case. The defense attorney and the adjuster are in another room. Adjuster's usually by phone, and available. But you're communicating, and sending messages through that mediator. But sometimes we are going, we do say, okay, Mr. and Mrs. Mediator, I'd like to, usually it's later in the process of the mediation. I want to talk to the defense lawyer. Like, here's where we are. We're $50,000 apart. How do we, cut somewhere where we can get the case resolved for what it's worth.
Right. We can always walk away too. Sometimes that applies pressure. We walk away. They want to get this case settled, and so do we. But only if it makes sense for the injured worker.
Yeah, and I love that because it's we're going to be honest, and I think that's important for those lawyers that are watching this. You can't be relying on that case because it's not about your interests and your monetary needs of the firm or personally. It's got to be what's best for the client. And if they're not offering enough, you want to be honest that this is not enough and we should keep fighting, or we shouldn't resolve, let them keep paying checks and treatment.
Right.
And a lot of times the first mediation is not the right time to settle the case. It's the second mediation.
Yeah.
Because by then they realize, hey, this is costing us a lot. And you'll be shocked at how many employers and insurance companies do not make wise financial decisions, just keep paying on a case, and then a year goes by and you can see how much money they've spent in that year, and they could have settled the case for X the year prior, and sometimes it makes no sense on a cost-benefit analysis. Well, thanks for joining the Stephen Hasner Show, Pearce. Appreciate you joining us.
Anytime.
Remember to like, share, and subscribe, and we'll see you next time.